Thank you so much. This is Cecelia Friedman Levin, and I am Senior Policy Counsel with ASISTA. I am joined today by my tremendous colleagues, Amy Cheung and Laura Flores Bachman. And today we will be discussing with you representing survivors during this COVID-19 pandemic. And first, I just wanted to say thank you for joining our webinar today. And I know that all of you as practitioners are under enormous strain, and that I hope you and yours are all doing well, and that ASISTA hopes to be a resource for you and for your clients as we kind of move through this crisis together. So I just wanted to say at first that I am very grateful to and for all of you. So today I think our agenda is pretty straightforward. We're going to be talking about issues that have come up in your survivor-based immigration cases. So issues that you might be facing in terms of your file with self petitions, U visa, T visa filings, and how particular and unique challenges that have arisen for circumstances due to this pandemic. And then to talk through some options, which might be fewer than we had before, but it's an opportunity for us to think through might be available and kind of think about some strategies to address some of the challenges that survivors are facing during this time. And so I think now our first issue that we'll be talking about is the issue of deadlines. And there's some news about this just today, so I'm sure that we will go for and explain the very latest updates in terms of working with deadlines.
Yeah, so this is Laura. Good morning or good afternoon, wherever you are. Thank you again for joining us. So I'll start off with deadline issues that have been exacerbated by this pandemic and how to deal with them. As Cecelia mentioned, yes, we do have up-to-the-minute changes from the slides that you are going to see. We'll start with the USCIS policy response deadlines during the national emergency. In your chat box, I just put the very latest. There's two separate links. And I guess there was not a space between the two links. Let me try that one more time. I'll try that one more time and see if I can get a space in there so that you can link to the announcement. But essentially what the announcement has done is that it's extended the RFEs, notices of intent to deny, notices of intent to revoke, the response time for those that were issued between March 1st and now July 1st inclusive. So if you received a request for evidence, a notice of intent to deny, a notice of intent to revoke, and certain other applications that you'll see on the list, I don't think they'll apply to many since one is a notice of termination, but it's for certain employment-based visas, so it doesn't apply here. And we'll talk about I-290Bs in just a bit. But essentially what the notice did today was instead of March 1st through May 1st issuance dates, it now covers an extension of 60 calendar days for those RFEs, NOIDs, and NORs that were issued between March 1st and July 1st, 2020. You may submit a response within 60 calendar days after the response date that was included with the request or with the notice. So that 60 days has stayed the same, which is great. So if your response date, for example, was a deadline of June 1st, you would have 60 calendar days from June 1st. So who's left out? The responses that are still left out and were still not included with today's announcement or RFEs, NOIDs, and NOR responses that were issued prior to March 1st, even if the deadline is within this period, March 1st through July 1st. So even if you're required to respond within this pandemic time period that USCIS has set out of March 1st through July 1st, there is no automatic extension. And we'll talk a little bit about what you can do in those circumstances. But first, I kind of wanted to get a sense, have you been having trouble, right? Between March 1st and today, have your clients had difficulty obtaining evidence or information needed to respond to an RFE, NOID, or NOR, or have you had difficulty, right? Have you had difficulty getting in touch with your client in order to get information or permission, etc.? We're just trying to get a sense, and the reason we want to do this is not only to be able to help you, but also as part of our advocacy work with USCIS. We've been polling our members during our calls and during our webinars to be able to reflect back to USCIS, you know, that our members, that our OVW grantees are expressing, you know, a need for more time and having trouble getting the evidence during this time, regardless of when those requests were issued. So this is great to know. It looks like 75% of you say that either your clients or yourself have had difficulty during this time in getting information. So thank you for submitting that. So let's talk a little bit about what do we do. We'll start with a hypothetical. So a request for evidence was issued before March 1st. The RFE requests a new I-918B LEA certification. And USCIS indicates that the original LEA certification did not include the statutory citation for the qualifying criminal activity. They also request copies of all pages of the petitioner's passport, or in the alternative, an I-192 waiver for that passport. And your deadline is next week. It's March 8th. So you requested a new I-918B several weeks ago, but the LEA has not responded and probably will not respond before that May 8th deadline. The copy of the passport was previously submitted, but unfortunately the hard copy of the submission is in the office in a paper file and you don't have access to those copies. So that's your hypothetical, and this hypothetical comes from pretty much what we've been seeing in our technical assistance requests. So let's talk about what are the implications, right, in this type of situation. So because of COVID-19, practitioners can't go to the office. Because of COVID-19, clients can't go to practitioners' offices. Consular offices in the U.S. from the client's home country are open for emergencies only, and perhaps don't see you know, this as an emergency, just the issuance of a passport that obviously cannot be used to travel, right? So maybe would not be able to get that. Documents or evidence to respond to RFEs, particularly from law enforcement agencies, will probably be pretty difficult because they won't be, and we've heard from many of you that your local LEA is not prioritizing requests for recertification, and in many cases, not even requests for initial certification, just based on, you know, everything else that they're having to deal with because of COVID. And then, of course, DHS itself is affected, right? Vermont Service Center, currently their phone hotline is temporarily unstaffed, so you're not able to just call and kind of work through the issue that you're having in terms of needing an extension, even though it is prior to March 1st. And then, of course, email hotlines may be slower to respond. we've actually heard from some practitioners that they've been getting pretty good responses from NSC and VSC. I guess it really has been hit or miss. Some have had responses, pretty quickly. Others, it has taken a little bit longer. So do continue to try that email hotline. But anyway, this kind of gives you a sense of why it matters during this time to get an extension and really to be in touch with your clients as much as possible immediately upon getting a notice. Before I move on, I'm just looking through the questions right now, and it says, my VAWA RFE requests criminal background checks in Colombia. Been harder to get any response from Colombia so far. Well, yeah, absolutely, right? I mean, I think just as law enforcement agencies here are not prioritizing requests that are not considered emergencies, I think we're seeing this all over the world. So in addition to probably, also slow getting, mail from Colombia, it's going to be difficult dealing with background checks and other of those issues. Another question I'm seeing is, what hotline do you mean? What hotline email? So there is a hotline email for U's, T's, and VAWAs to get in touch with the Vermont Service Center or the Nebraska Service Center, the units dealing with those particular applications. I don't have it in front of me right this minute, but I will put it in the chat before the end of our presentation today so that you have it. And we'll also include it in our follow-up email after today's webinar. So some practice pointers as you deal with these RFEs and having to timely respond. I guess that's the first practice pointer, right? Plan to timely respond if your notice is not covered by the USCIS COVID extension guidance. So go ahead and plan on responding even if you don't have everything that you need, right? If the client wasn't able to get all of the evidence, remember to include the evidence that you were able to get, explain how that evidence is, meets the any credible evidence standard, and also meets the, together with what you submitted before, should be sufficient for them to make a decision on the merits, rather than finding that making a decision claiming that you did not respond and therefore abandoned the petition. So first and foremost, statements that you make in your cover letter themselves, those are legal arguments and are not considered evidence, right? So it will be important if you need to state what steps your clients have taken in order to obtain the evidence and were not able to get it, consider a declaration from your client directly, right? And then your client can explain, these are the difficulties I've had. Your client can also explain their client-specific hardships, right? Because every client will have different hardships during this time, depending on, number one, their personal situations, which could include transportation. It could include the fact that perhaps they're unfortunately having to shelter in place with an abuser, or they are sheltering in place at a domestic violence shelter, and that shelter has additional restrictions on their ability to travel or to come in and out of the residence, et cetera. So that's what we mean by client-specific hardships. But what we also mean is the wider picture, right? Where is your client living, and does that city or town have additional restrictions? Does that city or town's law enforcement have, just a kind of a general notice on their website, or a notice that they've issued publicly saying, the restrictions that the law enforcement agency will have itself during this time of COVID? Get as much specific information as to your client's hardships in their locale and in their personal circumstances, so that you can show in your client's declaration the steps that she was or they were able to take, what they were able to obtain, and then what they were not able to obtain, but also why they were not able to obtain it. Unfortunately, if you have a situation where the notice that you are responding to was issued before March 1st, pointing generally just to the COVID pandemic is not going to be enough for these cases, because of the fact that USCIS has specifically left these cases out, right? You have to make a more concerted effort to show the difficulties in your case specifically. And so in addition to what you are submitting with the request, go over the evidence that you previously submitted. What we are also finding is that in some instances, perhaps USCIS is not recognizing evidence that you previously submitted. So if you previously submitted all pages of the passport, for example, reference that. Obviously, if you have copies of it, submit those. But if you're not able to get a copy of what you originally submitted because you don't have access in your office, then specify that as well, right? We submitted all pages of petitioner's passport on X date together with the original I-918. Your office received it on such and such date. We will provide additional copies if you require them as soon as we are able to enter our office. Now, in that situation, if it's dealing specifically with your inability to get into the office, it would be also helpful if you have something from, for example, if your office rents space and you have something from the property management company that says, the building's closed, you can't come in, submitting something like that, why not, right? Show them you're not just trying to delay a response in any way. But the other reason for pointing to what you've submitted before is, again, you want to get a decision that's based on the merits of the case, because that makes your client, if unfortunately you get a denial, but it's based on the merits of eligibility, then your client's able to appeal that denial. Whereas if you get a denial for abandonment, either for not responding to the RFE or USCIS claims you did not respond sufficiently to the RFE, and they make a decision denying your case for abandonment, then that might limit what you can file in terms of a 9290B. You'll file it as a motion to reopen or reconsider rather than as an appeal. Now, obviously, you may still file it as an appeal and indicate why USCIS could have made a substantive decision, but it just gets you in that situation. You want to make sure you make it clear how your evidence previously submitted does meet the request from USCIS. So in your cover letter, you're also going to want to ask USCIS for an extension and advise them that you'll supplement the RFE response. Show specifically the additional time that you need, because again, every client's circumstance is going to be different, and if you leave it open-ended, number one, USCIS may not provide a response in the amount of time that you need and not give you more time, or number two, the time that they do grant for an extension may not be sufficient given your client's specific circumstances. So think that through a little bit, talk with your client to figure out a realistic timeline for obtaining those documents. I mean, there may be some circumstances where trying to figure out a timeline may be out of your control. For example, if a consulate is closed and you have no idea when they will reopen. But at the very least, if you're able to get copies from your file, then that might be a way for you to kind of figure out a good timeline. If you did not submit evidence or response to a notice of request, a notice or request in a timely manner, for reasons that are directly tied to a special situation. You can also show how this disrupting event affected your client. So this is USCIS's kind of general caveat for accepting untimely responses. But in this situation, which is different from their general flexibility that they've announced, here you actually have to show that nexus, to show how your particular client's situation and inability to respond to their request is directly tied to, in this case, COVID-19, right? You have to make that connection for them. Whereas for those cases where the notice was issued after March 1st, you don't have to make that connection. You can just say, issued after March 1st, your notice says we have an additional 60 calendar days, right? So look at that special situations link that we're including in the PowerPoint. That special situations guidance has actually been provided by USCIS since October of last year. So that's useful only because it may be your inability to file the response doesn't necessarily have to be COVID related. If there are other special situations that are affecting your client's ability to respond, include those as well, pointing to this guidance. Okay, let me just check really quickly and see if we have some questions on this. So the question we have is, my pro bono attorney got an email response, the RFE for biometrics for derivative in the Philippines, and they advised her to respond timely to the RFE, and they wouldn't reissue the biometric, and they would reissue the biometrics notice. Okay, yeah, great. That's actually good to know that that they received some helpful guidance through email response, so that's great. And Amy will talk a little bit more about requests for biometrics in just a few minutes. Okay, so this slide has completely changed as of this morning. Okay, so USCIS's policy on I-290B deadlines. So right now, as of this morning, so the policy on I-290Bs has been clarified, which is the good news. USCIS has stated that I-290Bs for motions to reopen and appeals that are based on decisions issued between March 1st and July 1st receive 60 calendar days, as they did in the first announcement, but it's from the decision date. So remember, this is a little bit different than your RFE flexibility or NOIDs or NOIRs. In this case, instead of going from the date that that your deadline expires, right? Instead of adding to your timeline, it actually just goes from the decision date, right? So if normally you would have 33 days from the date of decision to file your I-290B, you now have 60 days from the date of the decision. So it's not 33 plus 60, it's just 60, okay? So that's the difference between the I-290B deadline, filing deadline, and the RFE deadline flexibility that was provided, okay? So the good news is that they did clarify. There was some uncertainty before as to whether this included motions to reopen, just based on how the language was worded in the initial notice from USCIS. But in this notice from today, they updated the language, and they actually updated it in both the, in today's notice, they put I-290B for motions and appeals, and then in their general USCIS web page on COVID-19, they also updated the language there. So it just specifically says I-290B. There's none of this additional language that they included before that said from an appealable decision with a jurisdiction, et cetera, et cetera. So that language has been taken out, which we think is at least helpful. But again, just as with the RFCs, it's from those decisions that were issued between March 1st and July 1st inclusive. So if you had an I-290B before that time, a decision issued before that time, and you need to file an I-290B for that decision, then you still have the same usual deadline as before. And again, we're saying the same practice pointer here. File on time, but go ahead and include if you have special situation that is keeping your client from being able to fully submit evidence with the I-290B filing, then include that in there to let them know that you'll be submitting additional information. Okay, I'm not seeing any questions here, so I'm going to turn it over to Amy to discuss some initial applications and initial evidence, what to do during this time. So Amy.
Thanks, Laura. Hi, everybody. So continuing this discussion about filing deadlines, they're relevant to the issue of initial applications because USCIS has not extended any of the statutory or regulatory filing deadlines except the ones that Laura has already mentioned. And so what this means is that even during the pandemic, you're still having to comply with deadlines related to filing of OSL petition within 2 years after the divorce or death of the abuser, filing U visas within 6 months of the signing of the certification. Age outs also remain in place, so filing 918s before the principal turns 21 or before the derivatives age out, all things like that. So all of those deadlines at this point remain in place. We have asked USCIS to suspend deadlines and toll age out issues, but we haven't gotten a response yet. Of course, we'll let you know if we hear anything, but at this point, there's been no change, right? And so what that means is that in the meantime, even though USCIS has made certain accommodations for RFE responses and 290Bs, you still have to comply with all of these other filing deadlines. And of course, the same issues that might prevent you from responding timely to an RFE or a NOID would also be relevant to an initial filing. And so what we're seeing is that folks are having increasing difficulty putting together the evidence and getting the documentation, the signatures, and all of the logistical things that they need to submit an initial filing, and there haven't been that many accommodations so far. So let's talk about what some of those issues are and what some of the accommodations are that USCIS has put in place, and some suggestions that we have where those accommodations don't exist or might not be sufficient. All right. So signatures. Obviously, forms need to be signed. USCIS has said that it's okay to submit a form that is an electronic reproduction of a wet signature. So what they've said is that normally you would need to sign the form, and then certain forms such as the 918B have to be submitted in the original, within original signature. Now, under this new flexibility policy, you could submit a photocopy or a scan or a fax or some other kind of electronic reproduction of that original signature page, and that would be acceptable for USCIS. They still recommend that you keep the original signature page for your records because USCIS could ask for it at a later point, but for now they'll take the non-original. But then this still leaves the question of, oh, But what if you can't even get an electronic reproduction of an original signature page, right? So specifically, what about electronically produced signatures, such as ones that you would make with DocuSign and other similar software programs, or something that you could sign on your computer or your tablet? USCIS hasn't said that that's okay. EOIR has put out their own policy, and they've said that that's okay for EOIR filings, but for USCIS, there's no such accommodation at this point. So we would recommend, just in the exercise of caution, we would be hesitant to do that if there's any way around it. The other thing that some folks have talked about is, well, what about client signatures? What if there's just no way to get this document to my client to have them sign it? Can I have my client sign a blank piece of paper, have them take a photograph of that signature and send it to me, and then I will copy and paste it into the forms? So USCIS also has not said that that's okay. And just like for the electronically produced signatures, we would be hesitant to recommend that people do that. I think the thing to keep in mind as we're talking about all of these issues with filings these days is that keeping in mind that you still have these statutory and regulatory deadlines to comply with, and that the consequences of not meeting those deadlines could be dire for your client and their family, right? Like they could lose their eligibility. You do the best you can. But to the extent that you are able to get a signature that complies with what USCIS is saying is okay, do that. And then to the extent that you really, really, really cannot, and you're coming up on a deadline and you have to file, tell your client what the risks are, right, so that the client understands what could happen, and document your conversation with the client, document that your client has given you permission to file in this way, that you've advised them about the risks of filing in this way, explain to USCIS why you're filing in this way, the impact of COVID on your ability to obtain a signature, and then do the best you can, right? Like, what else are you going to do? I've seen a couple comments in the chat box. One person has said they filed with copies of signatures for clients, gotten a receipt notice. Client signed the document, scanned it to me. Right. So scans of original documents are okay under this flexibility policy, right? So I wouldn't expect to have problems with that. What about photographs of the client signature on the form? If you're talking about a photograph of a standalone signature that you're copying and pasting into a form, then I think that that's potentially risky because USCIS hasn't specifically said that that's allowable. And you wouldn't necessarily find out right away, right? I mean, this might be a question of not of the mailroom review, but of later review when they're actually adjudicating the case.
But what if, for example, like you had a signature page of a 918, right, and the picture, and someone took a picture of their original signature? You know, with that photograph, I guess if you can kind of like convert it to a PDF or otherwise, would that be a safer bet?
Like a photograph of the entire page with the signature on it?
Mm-hmm.
I think that would be okay. I mean, they haven't specifically, they haven't excluded the idea of a photograph as an electronic reproduction, and I think it's substantially similar to a photocopy or a scan.
A scan,
right? And a photograph that you convert to a PDF is indistinguishable from an original PDF, right? So I don't think that that would be a problem.
All right. Hopefully that helps, Kelly. Thanks, Amy.
Great. All right, moving on. What else? Biometrics. So, update to this. ASCs are currently closed through June 4th. So they updated that recently. And the expectation in the last announcement seemed to be that they expect to open on or after June 4th. But we're going to see exactly what happens as we get closer to that date. And so obviously all biometrics appointments have been canceled. The ASEs closed on March 18th, so anything between March 18th and at least June 4th was canceled. And once the ASEs reopen, then they should automatically reschedule all of the canceled appointments. And after, obviously, it goes back to the same policy. After the ASEs reopen, if your client can't attend their appointment, then you have to request a reschedule, right? That's the same as always. USCIS has also said that they will process I-765 renewals based on previously submitted biometrics. If your client wasn't able to provide biometrics during this time for the new application. And we've heard anecdotally from many people that they're actually processing applications based on previously submitted biometrics for all types of forms, or at least several different types of forms, not just 765 renewals. So if your client has previously done biometrics for USCIS, there seems to be a pretty good chance that they will process a new pending application without making them take new biometrics at this time. But the only official announcement has been for 765 renewals. Okay. Do we recommend waiting to schedule initial biometrics for clients and removal until after June 4th, or should we submit sooner? I don't really see a problem with submitting it sooner. It's up to USCIS to schedule it for a date when the ASEs are open, right? So I don't think you lose anything necessarily by submitting the biometrics request sooner than June 4th. Particularly if you have an individual coming up or something like that and you need to have biometrics done by a certain date. All right, local office appointments. Likewise, field offices have been closed until June 4th, and so that could obviously change as well. So keep checking the USCIS office closings website or check your USCIS notification emails to make sure if that date's going to change. But right now it's June 4th. And like for ASEs, if USCIS canceled your interview at the local office, they will reschedule that automatically. If you had an info pass, then you would need to reschedule that. They're not going to reschedule that automatically. Obviously, there are reasons why folks would need to go to the local office even now for emergency reasons, whether it's advanced parole or something else. And so USCIS has said that you can contact the contact center to request an emergency in-person appointment. One potential issue that we've heard is that for VAWA and TVPA cases, so VAWA, U visa, T visa, it can be difficult to get any information or assistance from the USCIS contact center because they've been told that anything covered under 8 U.S.C. 1367, for any of those cases, they can't disclose any information over the phone. And so if you are having trouble getting an emergency appointment through the contact center for this reason, first we would recommend asking to speak to a Tier 2 representative or a supervisor to try to explain to them what the problem is, because sometimes the Tier 1 representatives don't necessarily have the information to be able to help you better. So try that first. And if that doesn't work, then please let us know and we'll try to see what we can do to help. No guarantees, but we can try to escalate the matter. And out of curiosity, has anybody tried to get an emergency appointment through the contact center for a VAWA Tier U case during COVID? If you have, if you could tell us about your experience in the chat box, that would be great to know. Okay, and while we're waiting for any responses to that to come in, let's talk about passport photos. So passport photos are still required for certain types of applications, like the 765 and the 485. And so it's obviously difficult and in some places potentially illegal to go to a normal place where people used to go to get their passport photos to submit them to USCIS. So what do you do? We've heard from some practitioners that they've had luck in getting their clients to download a cell phone, a passport photo application on their cell phone. There are a lot of free ones out there, and they will size the photograph for you and make sure it's compliant with the passport requirements, which are the same as the USCIS requirements. And then your client could then send you those photos, and then if you have access to a photo printer, then you can print it and cut it out and submit it with the application. So there are some folks who've been able to do that. If you're able to do it, I think it sounds like a really great workaround. Obviously, it's not necessarily feasible for everybody. We've also heard of folks who've been able to, if you don't have a photo printer, but the client does have the ability to take a picture with the white background and send it in. I believe is it Walmart or Walgreens? One of them has the ability where you can send in your photograph to their website, and they will print it out and mail it to you. And there might be other stores where you could normally go for photographs that might have that same service available. So that's another option if you can take the photo but you can't quite print it out. We do recommend submitting the passport photos with the 765 and 45 because they are required for those applications, right? And so you wouldn't want to run the risk of the application potentially being denied later on for lack of required initial evidence. We don't know necessarily that USCIS would deny cases on that basis, especially if the reason why you weren't able to obtain photos was the COVID epidemic, but better safe than sorry. And if you aren't able to, then we would recommend following the advice that Laura gave earlier about documenting why you're not able to comply with this requirement right now, and then obviously supplementing the application as soon as you can with those photographs. Okay. Medical exams. So these are still required for adjustment of status, but they are generally not required at the time of the initial filing, and under COVID, they still are not required at the time of initial filing. So you can file your adjustment of status applications and then wait for an RFE to get the medical exams. Obviously, a lot of civil surgeons right now are not doing these optional in-person exams for USCIS purposes. So we've heard that it's quite difficult to get these. Okay, is an inadmissibility waiver considered required initial evidence? So according to the checklist for U visas at USCIS.gov, yes, it is required initial evidence. And so we would recommend submitting your 192 with the 918 if your client is inadmissible. So far, we have not seen USCIS deny any 918s purely on the basis that the person didn't file an inadmissibility waiver at the same time that they filed their 918. But according to the checklist, this 192 is required initial evidence. So if it's clear that your client is inadmissible, then we would recommend submitting the inadmissibility waiver at the time of initial filing. Okay. Can you just skip the initial evidence and wait for an RFE? Well, it kind of depends, and there's some risk assessment here, right? So there are particular things that are considered required initial evidence, such as passport photos. Signatures aren't on a list of required initial evidence, but forms are required to be signed. Typically, forms that are not signed will be rejected, right? And so whether or not you can wait for an RFE, I think depends on what it is that's missing. And also, there's always a potential risk that USCIS could strictly adhere to the RFE memo, under which they can deny cases without an RFE if you're missing required initial evidence. And the NTA memo remains in effect as well, right? So if your case is denied and you don't file a 290B timely, it's possible that USCIS could issue an NTA. So when it comes to initial filings, do your best to do everything that you're supposed to do for an initial filing. if you're coming up on a deadline and your client's at risk of losing their eligibility if you don't go ahead and file, but there's just something that is absolutely impossible to obtain right now because of COVID or some other reason potentially, but we're talking about COVID right now. So follow the advice that Laura was talking about earlier with the RFEs, right? So document what it is about COVID that is preventing you from obtaining the required thing at this time, whether it's printing out shelter-in-place orders, printing out documents showing that a particular office is closed, getting us a signed statement that your client your client's not able to leave their house because of X reason, your office is closed because of X reason, whether it's because of your state's shelter-in-place order or whatever the issue is, right? Money orders. So one option is, so fees are still due. If your client is not submitting a fee waiver, then they would still need to pay the filing fees. If your client is not able to obtain a money order, and obviously a lot of clients don't have access to checking accounts, one option could be if your office could cut the check on behalf of the client, so your client could give your office money and then you cut the check for them. There are also USPS offices that are still open and are still issuing money orders, so depending on your state, if that's allowed or not, that could potentially be an option. And what are you guys seeing? Are there any other issues when it comes to initial evidence that you guys would like to chat about, or any suggestions that you have for peers? I'm seeing one person saying that they tried to get an emergency appointment to get proof of LPR status, presumably in order to continue working in a hospital, which you would think would be a relatively high priority right now. I think in that situation, I would be curious to know if that person asked to speak to a supervisor or a Tier 2 representative, because sometimes they can be a little bit more reasonable. Because it really does seem kind of outrageous that a hospital employee at this time wouldn't be able to get an appointment to get proof of work authorization in order to continue serving. And one person says that they've sent 918s without 192 waivers and have gotten receipt notices with no problem so far. That's consistent with what we've been seeing. I mean, we would still recommend filing the 192 waiver with the 918 if it's clear that your client is inadmissible, but because you never know when USCIS's policy with respect to these procedures is going to change. But so far, that's consistent with what we've been seeing as well. And we have one question. Does the RFE memo mean that submitting in 192 after the 918 but well before adjudication could lead to denial for the 918 many years down the road? I think the question that we have is, at what point is USCIS going to review the filing to determine whether all the required initial evidence is there? So far, it seems like they've been doing the review at the time of adjudication, but we don't know that that's necessarily always going to be the same. Right? And so if they start doing a separate review before adjudication to see if all the required initial evidence is present, then it's conceivable that it would not be that many years down the road. Okay, and it sounds like that 751 client did speak to a supervisor but wasn't able to. So the Tier 1 representatives are supposed to pass you on to a supervisor whenever you ask for it. So I would probably, I mean, it doesn't sound like it's too much of an issue right now, but if it becomes an issue, you can try calling back to speak to a different Tier 1 representative, because they are supposed to make supervisors available when you ask for them. Question about fee waivers. Clients are having trouble gathering evidence for the fee waiver in light of COVID. Can we make COVID-specific arguments for the fee waiver? Yes, definitely. Please do. And so you would, the kind of evidence that you would be submitting would be very similar to what you would submit for RFEs where you're not able to get all the evidence for that, right? So it could include a client affidavit where they're talking about attempts that they've made to obtain evidence or like why particular evidence is not available. It could include printouts of government websites or other types of websites showing that places are closed, things like that. But yes, you can definitely make COVID-specific arguments. And certainly folks who've been laid off or furloughed because of COVID would be able to make income-based arguments on that as well. One person's asking, should they send off applications without passport photos? Should they send in the photos with the receipt notice as soon as possible? I would recommend supplementing your filing with passport photos as soon as you can, just because we don't know exactly how USCIS is going to treat those. Okay. All right. And I think that leads us to consular processing. So Laura, I think this is you, right?
Yes. So in addition to USCIS changes and need for changes during COVID, we've also seen several issues relating to consular processing and executive orders dealing with travel into the United States. So that is what we're going to tackle next. And we'll start with a hypothetical. There's a U visa holder who has adjusted status, and the U visa holder's derivative child's I-929 has been approved. But the derivative beneficiary is turning 21 May 5th. So on May 5th, that child will age out, and as you know, on the I-929, in order to enter as a permanent resident, as a derivative of the U who adjusted status, they have to do it prior, actually enter the United States on an immigrant visa prior to their turning 21. So this is an age out issue, and important to get the person here by May 5th. The derivative beneficiary had an interview already at the consulate, but the consulate officer required a medical exam from the derivative before deciding whether to approve the visa application. Derivative cannot get the medical exam because those offices have been closed. So what does the derivative do? What can you do for this client? And what additional information do you need in order to determine your next steps? If you've got some questions that you'd like to ask about this derivative before deciding on next steps, put them in the chat box. Amy or Cecelia, I don't know if you can think of any questions that you would need to ask or get other information before deciding next steps. What do you think, either of you, if you have any suggestions? One thing that I would want to know is, why is the consular officer asking for a medical exam, right? What is the ground of inadmissibility that the consular officer is worried about? And is there a workaround? Is there some other evidence that you can try to get in order to demonstrate eligibility? Another thing would be, did the derivative, sorry, I put NIV interview. I meant IV interview. I meant immigrant visa interview. Sorry about that. I added an N there. I don't know if you guys got it or not, but I just got it. One thing that you might look at is, why are they asking for a medical exam if they are adjusting just as the U principal did under 245M, right? Is there a medical ground and admissibility ground applicable here? And since it's not, then what are they looking for, right? What is the discretionary reason that they would need this medical exam? So those are the things that you would want to start just asking. And the reason you'd want to start asking that is just to see if there's a workaround that would not involve either having to get a medical exam or an additional interview at the consulate, given the current circumstances. But why also is this important right now? Well, let's talk about why this is important. The Department of State, as of March 20th, has temporarily suspended what they call routine visa services at all U.S. embassies and consulate. And anything that was considered routine in terms of immigrant and non-immigrant visa appointments were canceled. And there's no rescheduling time period right now. There's no specific date for when they're going to resume routine visa services. And so obviously that's why this is a concern in that limited circumstance of an age out for an I-929 that's been approved. How do we work around this? So that's where we're at right now. Temporarily suspended routine visa services as of March 20th, and we don't know when it's going to resume. What we do know is if you've paid a visa fee, but your client's appointment was canceled, that visa fee is still going to be valid in the country where the visa appointment was made. So at least, you don't have to worry about clients losing that visa fee. Embassies and consulates will continue to provide emergency and mission-critical visa services, but only as resources allow. And what does this mean? What it means is that you really need to look at the individual consulate or embassy that your client is dealing with, because if the embassy has resources, then they could process emergency cases or mission-critical cases. So, for example, medical personnel who are coming to work with or treat or mitigate the effects of COVID-19, they have found that those would be considered mission-critical. Is an age out of a derivative considered an emergency? Well, we hadn't had a specific answer on this in terms of, a DOS notice. However, in a recent filing in a federal litigation case, a case dealing with some of the restrictions caused by the stoppage of consular services, there was an affidavit submitted by the division chief in the visa office for the Department of State. And in that affidavit, they clarified that posts will continue to provide mission-critical emergency services, and the department includes mission-critical and emergency services, the processing of immigrant visa applications where the applicant would soon turn 21 and age out. So we have this declaration as part of a lawsuit that was submitted as evidence into a federal litigation, into a federal court that does specify that an age out would be considered in that caveat of emergency or mission critical, but it does also say if the resources allow. So if you have a situation like this, the first step will be to visit the website of the consulate and contact the consulate directly. If you have a difficult time contacting the immigrant visa line, either telephone line or email line, depending on what that particular consulate has, because there are still services to U.S. citizens, there has to be a point of contact for U.S. citizens. You can always try using that particular email or emergency line for U.S. citizens in order to try and get information from that consulate about whether there are resources for this emergency age-out situation. So that was actually, that declaration actually was just filed recently, so it was good to get at least some confirmation that the visa office would consider this an emergency. The other thing I would say is that if your consulate or embassy has the resources, right, but is not considering this an emergency, do contact the DOS visa office in DC to get your consulate to work on this age out case, right? Since the visa office has specified that yes, this is an emergency situation. Okay. What else? Things are still going on with USCIS and MVC during this time. So even though the consulates have stopped their visa processing, USCIS is still sending petition approvals to the National Visa Center. National Visa Center is still creating DOS case ID numbers, is still creating the files, is still issuing fee invoices, still collecting documents. So it's important to continue working with your client and keep the stateside part of the processing going even during this period. The reason that this is important is, of course, for the age outs that we've already talked about, but also remember that your client still is subject to may still be subject to 203G, which requires that your client take steps to get the visa within 1 year of the immigrant visa being available. So it's important to still, as much as possible, continue to work with MVC in moving the case forward. And if you're having issues, I would say the practice pointer here is still communicate with MVC, let them know that your client continues to be interested in pursuing the immigrant visa, but at this time isn't able to, something to get on the record, number one, that they're represented, and number two, that they still are interested in applying. The second thing we have to take into account with travel in and out of the U.S. is that in addition to the consular restrictions, the CDC issued its own temporary border suspension. So DHS is implementing the CDC border entry suspension at ports of entry on the north and south borders. So if your client is coming in through a port of entry through Canada or through Mexico, and I should say a land port, the CDC ordered suspension, I'm using the language that they used, which is suspension of the introduction of persons. So basically, of the entry of persons at the borders traveling from Canada or Mexico through land ports, okay, so that's important, land ports of entry, who would otherwise be introduced into a congregate setting. So we saw in conjunction with this order, it affected things like MPP, right? All the persons at the border trying to request asylum, all of those cases have been put off, and that's been extended through June 1st. This particular CDC announcement generally, which was announced in March, was through April 20th, but on April 20th, they extended it through May 20th. We don't know yet whether there's going to be a further extension. So now we're keeping track of different deadlines, right? So a little while ago, we talked about flexibility by USCIS. That was a July 1 extension. Here, we're talking about May 20th. The consular was just indefinite. So there's a lot of, it's important when you're dealing with your individual clients, depending on where they're, whether they're in or outside the United States, to keep track of these various restrictions, when they're in place and when they expire, just in order to maintain, maintain your client current as far as responding to things or asking for appointments right away once these restrictions are lifted. So generally, this seems to affect everybody, right? Anybody being quote unquote introduced at a land port of entry. But there are a lot of exceptions, right? So this suspension of land entry, border entry, does not apply to U.S. citizens or lawful permanent residents, and it doesn't apply to their spouse and children. Doesn't apply to U.S. military or associated personnel and their spouses and children. Persons with valid travel documents who arrive at a port of entry. Now that's an interesting one, right? Because maybe a border crossing card, right? Is that a valid travel document? Well, no. I mean, we've gotten clarification, and what they're talking about here is if there's some special parole or some other special travel document that they are issued. So, for example, in your age-out case, if you have the visa issued and they are given their packet to enter at the port of entry, they can be allowed in. Persons in the visa waiver program not otherwise subject to travel restrictions may also be allowed to enter. May, but not required, right? And then there's this kind of big exception. CBP officers can determine someone else who should be accepted from this general travel ban, or suspension, I should say. The CBP officer can look at the totality of circumstances and can look at whether there is a significant law enforcement, public safety, humanitarian, or public health interest. This was really important because there may be a situation where you have a client who needs to come in on humanitarian parole or has some other reason why they need to present at CBP rather than presenting at the consulate, right? If there is an emergency situation and you can document this significant law enforcement, public safety, humanitarian, or public health interest, and your client doesn't have any other options, well, I do think it is worthwhile to try and document to CBP why they should be accepted and be allowed to enter the United States. So I thought that was an interesting exception that gives quite a bit of deference to the CBP officers to make that call. And then, of course, DHS will consult with CDC to determine, any individualized exceptions. So while there's deference to CBP officers, obviously DHS is consulting with CDC. If they're making these exceptions, what's the best and safest way to make these exceptions? And there's this general caveat, right? The suspension may be extended if necessary to protect public health. And this is kind of something that's been worrying a lot of people, right? That if the public health crisis continues, this suspension may continue as well. We don't know. It may get extended month to month. For now, it has that extension through May 20th, and so we'll see whether at that time it's extended once again. So it is kind of open-ended. So we have a question here. Is a valid non-immigrant or immigrant visa a valid travel document? So technically, right, that could be a valid travel document, but what did they say? Who are the types of people exempted? And they didn't refer to non-immigrant visa holders specifically, right? They referred to lawful permanent residents. So I would say if you have an immigrant visa at entry, you would be entering as a lawful permanent resident. So you make your arguments. Unfortunately, the guidance isn't super specific there. I would say that CBP has updated their guidance. I'm going to put the link. There's kind of a general CBP guidance that they've been updating and that they updated on April 22nd to go along with this CDC suspension, and I've put it there in your chat box. which seems to indicate no. I mean, they don't want NIV visa holders to come in unless they also fall under one of these exceptions, right? So if you have an NIV visa holder where there's a significant law enforcement, public safety, humanitarian, public human interest, some kind of reason why they need to enter at the land port of entry, then that's what you're looking at there. Otherwise, what if they have a visa and they're coming in not by land entry, but they're coming in by air travel, right? So they're coming into an airport. So this specific CDC suspension doesn't apply to that. This is specifically dealing with our borders, right? I am going to turn it over, though, to Cecelia, who's going to talk about the executive order, which, of course, was much broader. So let's talk about that for a minute.
Right, and I think to recap, there's a lot of moving pieces right now. Particularly when we're talking about consular processing, that we know that consular processing has been suspended. And those operations at the embassies and consulates, all routine immigrant and non-immigrant visa appointments have been suspended. And now on top of that, we're looking at these CDC temporary border suspensions. And now I want to put on top of all that the provisions as it relates to the executive order that was issued on the 22nd of April. And it restricts entry of certain kind of immigrant visas. So remember, we're talking about immigrant visas in contrast to non-immigrant visas. And immigrant visas are kind of for folks who are going to be here for as legal permanent residents, as like intending to live and permanently in the United States. So we're looking at immigrant visas, right, who are outside of the United States and who do not have a valid immigrant visa that was valid as of 11/59 on April 23rd of 2020, and, so there's that kind of, again, that plus symbol, who do not have an official travel document other than a visa, so who don't have a transportation or a boarding foil or any other kind of advanced parole document that was valid on that date or any date thereafter. So again, who is exempt? So who does this not apply to? This doesn't apply to folks who are already LPRs. It does not apply to spouses and kids under 21 of U.S. citizens, including prospective adoptees. It doesn't apply to members of the military and their spouses and children, to medical health professionals who are seeking to help with COVID response and their derivatives, employment-based immigrant investors, and interpreters from Afghani or Iraqi interpreters who have worked for the United States government, so this special kind of immigrant visa category. So these are folks for which that it does not apply. And so in the context of the work that we do, what is important here is that so if you are a VAWA derivative and who is kind of in your, the VAWA is based on being a spouse or child of a U.S. citizen, then that would mean that you are exempt from the order, right? And the other kind of does have a general exemption category whose entry is in the national interest or wouldn't further important law enforcement objectives in the United States. But to all others, so who it does apply to, so who is impacted by this, would be parents and adult children of United States citizens, spouses and children of green card holders. And so in the context of our work, again, this would be spouses and children abroad where their abuse is based on, I'm sorry, where the abuser was a legal permanent resident. And it would also impact diversity visa applicants and most immigrant visas based on employment. And so those individuals would not be able to obtain a visa to enter the United States for at least 60 days after the issuance of the order. So even if you have a valid visa, but you don't also have a valid travel document to enter the United States, you would not be able to come in until that 60-day period is over unless they fall under one of those exceptions. And so other survivor-based forms that this would impact would be approved I-929 applications, again, approved VAWA self-petitioners based on abuse by an LPR spouse or parent, and an approved VAWA self-petition based on being an abused parent of a U.S. citizen's son or daughter. So the important thing to know is that this will not impact any applications for individuals who are applying from within the United States. So if your client is here in the United States, or if your application is pending, this would not have any impact. And it doesn't completely stop all immigration into the United States. To date, it does not apply to folks who are entering the United States on non-immigrant visas, like U visas or T visas. Although the executive order does contain instructions to DHS to review non-immigrant programs and to make recommendations from there. So I think that we can see whether or not after that 30-day review, whether or not this executive order would be amended to have some kind of provision regarding non-immigrant visas. So the bottom line...
go ahead.
Oh,
no, I was just going to say, Cecelia, just going back to our initial hypothetical, even if, you know, there's, as Cecelia said, since there's so many moving parts, if you've got that age out of the I-929 derivative, you're going to need to first deal with the consular restriction and get it through on their standard of being, you know, emergency and or mission critical. And if you can get that far, then you're going to look at, can they get in through the land port of entry? Do they meet those exceptions? Or if not, is it barred under this general executive order for immigrant visa holders? And so one of the things I would say is not only do you want to request your immigrant visa at the consulate, you're going to also want to request some other travel document in this emergency situation, right? Some kind of travel foil that the consulate can issue so that when they get to the port of entry, or if they're flying, they have that additional, you know, quote unquote travel document that would give them the exemption from the executive order.
Right. Thank you for circling back with that, Laura. And I think that your hypothetical does a really good job of showing all the different layers there is right now for these types of applications and for consular processing. And so, again, the bottom line, if your client is here in the United States, it doesn't much impact them. But if you are in kind of those categories, or where you have an approved visa and don't maybe have a travel document, that it would be subject, I think, to the executive order. And there's a blog post on our website. I think that it does kind of explains this in more detail, so I will make sure that I post that in the website. And if you have any questions, or if you have cases that you think might be impacted by this executive order, please do reach out to us. All right, now I think I'm turning it back to Amy.
Amy, I think you're on mute.
Yes, I was on mute. Thank you. Sorry about that, guys. So, yes, detention and stays. So, COVID is obviously affecting our clients who are detained as well as those who are not detained, right? And when it comes to detention, there are some additional safety concerns and perhaps additional impetus to try to get the clients released. So let's start off with a poll. If we could pull the poll up. Great. So if you guys could just mark your response here. Have you successfully obtained release from detention for your client during the COVID emergency? And I know there's probably a range in terms of how many organizations have detained clients in the first place and how many detained clients your offices serve. So I'm sure some of you guys generally don't have detained clients at all and might not need to deal with this on a regular basis. But for anybody who has detained clients, I think it's important to consider some of the COVID issues around release from detention these days. Okay, so let's go ahead and end the poll. So I am going to assume that, so the answers were no. I'm going to assume that a lot of folks didn't respond to this because you generally don't serve detained clients in the first place. But let's just talk a little bit about detention, even if it might not be part of your daily practice. So what we see is that clients can get picked up in all kinds of ways, right? And so let's say in this situation, Lauren was arrested at work by ICE. She's been detained for 4 weeks pending removal proceedings. She hasn't had her first hearing yet. She has a U visa petition and an asylum petition application pending. And she has 2 USC children, and she's just found out that she is pregnant, right? And so now you would really like to help Lauren get out of detention because any detainee is always going, I imagine that any detainee would always want to be released. It's one of the most difficult positions to be in, but especially with 2 young children and also being in detention while pregnant would be especially nerve-wracking these days. So given that she is pending removal proceedings and it doesn't sound like she has any criminal history, your first option is probably going to be asking for a bond hearing, which she would be due for anyway. And EOIR is still open for detainees at this point and should still be conducting bond hearings. So that's one option. But let's say she's not able to get released on bond, or let's say you want to get her out before her bond hearing comes around. What else can you do? So there have been a number of individual and class action lawsuits filed over the last couple of months on behalf of ICE detainees who are at risk of contracting COVID infections in ICE detention. And one of the most helpful cases so far has been Freiheit v. ICE. And in this case, the judge granted class certification for ICE detainees with risk factors and disabilities that place them at heightened risk of severe illness and death upon contracting the COVID-19 virus. And in the decision itself, you can see the list of risk factors and disabilities that were specified as placing these individuals at increased risk. And I've included a link to that order in the chat box. And I think one of the really nice things about this order is that the risk factors and disabilities identified by the judge go well beyond the list of risk factors that are on the CDC website. The CDC website has a higher age cutoff and a smaller list of pre-existing conditions that can cause risk of complications, whereas the list of risk factors and disabilities in this Freiheit decision have a lower age cutoff and a longer list of disabilities, including psychological disorders that are not necessarily included on the CDC list. And so in this order, the judge granted a preliminary injunction requiring that defendants have to make timely custody determinations for detainees who fall under these categories, and that they have to do this regardless of whether or not those detainees have submitted requests for bond or parole. Okay? So it's everybody who falls into these categories. And so you have are detained, we recommend that you take a look at the risk categories and disability categories in this decision to see whether or not your client could fit into any of them. And it might also mean that you need to have a more in-depth conversation with your client about their health conditions, maybe more than would otherwise have been necessary. And then you can use this decision to request release on parole for your client from ICE. Okay. All right, and then there are also a couple other options or a couple other arguments on which you can base your parole request, one of which is ICE guidance. So ICE has also issued its own guidance about the custody review for detainees in light of COVID-19. The guidance is more limited than what the judge ordered in FIHAT, which is why we recommend looking closely at the FIHAT decision. But you can also look at ICE's own guidance as well. And so there was a recent email from ICE requiring their officers to review custody determination for these high-risk groups. And a question to clarify, this decision applies to ICE detainees outside California. Yes, FIHAT should apply to detainees outside of California. And so you can also take a look at this ICE guidance. It has a shorter list of risk factors than the FIHAT order, but it is also broader than the CDC guidance, so it's worth taking a look at this as well. And obviously, again, talking with your client to see if they have any health conditions, perhaps you might not have been aware of before. It's also important to note that these risk factors, according to ICE, are just a significant discretionary factor. They're not necessarily determinative of whether or not your client will be released during this period. But it should be a significant factor in that decision. So in your parole request, you can include arguments based on both of these issues. And now I'm going to turn it over to Cecelia to talk about other detention considerations in light of COVID-19, as well as state considerations.
Thank you, Amy. And I think in thinking through what options might be available, that, if one of the options to consider is a request for parole under 212D5, which is for humanitarian parole. And in that statute, it kind of talks about that the agency has discretion to issue parole for an urgent humanitarian reason or a significant public benefit. And so here, when you're looking at, the serious medical conditions, a lot of these are going to be kind of based on the humanitarian grounds. For the medical conditions, pregnancy, if there's minors in custody, there is a 2008 memo that kind of talks about the issuance of parole, and something that is very much in ICE's wheelhouse is whether or not someone is currently a witness in proceedings in the United States. You're going to have to show that the individual is not a flight risk or a security risk. And so this is something that, again, is by case review by ICE to make this determination whether or not they would be willing to grant an issuance of parole. And I think largely in the circumstances of COVID, again, that would be on the humanitarian grounds. Or if there is a proceedings, then I think arguably you can do the significant public benefit as well. The other thing that is really important and that we have talked about in other contexts would be applying for a stay of removal. And this applies to individuals who have an unexecuted final order. So what does that mean? That means that maybe your client has an in absentia order or is in proceedings potentially and has an order that was issued more recently. And this is an application on the form 246, which is filed with ICE ERO. And in it, you would fill out the form, the G28. There is a filing fee. and talk about why your client would would warrant a favorable exercise of discretion. And so there we typically have kind of issues that we have built. Maybe if you're doing a 192 analysis, right? What are the favorable factors that would warrant a positive decision? And so a lot of that might be related to the victimization that one suffered. Maybe there's additional hardships at the moment related to COVID, and if that is illness or loss of resources because of the pandemic. You know, are there any additional hardships other than the typical ones which we have on this next slide? That would be relevant in survivor-based cases. And so that kind of includes, and I think that there are resources regarding sample stays. I know that we have them in a Dropbox, and so this is something, I don't know if they're on our website too. Amy or Laura, do you know?
They are on a Dropbox, but I don't think most of them are on the website.
Right, because they are very long and big files. So if this is something that you're considering, we can send you the resources. We have samples. We have sample declarations from your client and family members, and that would be used to support an application for a stay. And again, it is kind of why this person needs to remain in the United States. And kind of, again, looking at someone's, if they have long-term employment, if you have United States citizen children, if they have other positive equities that they're looking for, or maybe they have medical or other sorts of needs related to their victimization that they are trying to resolve or need ongoing treatment for, or if there's an open criminal case that they need to have access to the justice system to resolve that matter. So again, these are resources that we have in a Dropbox. We have samples available if this is an option that you wish to pursue. And again, when it talks about here with stays, I want to put on people's radar screens that this mentions the 2009 guidance on stays. And I just wanted to make sure that people were aware that there is new guidance on stays of removal that was issued last August. I'm putting that in the chat box so that you're aware of it. And so what it basically does is rescinds those 2009 memos and says that ICE will now look at the kind of totality of the circumstances. The memo says that they will no longer routinely request prima facie determinations from USCIS, but that they will look at kind of the favorable or adverse factors, any federal interests implicated, and that it will, including the assistance provided to law enforcement, to prosecutors in the investigation or prosecution. And it says that that will generally be considered to be a significant favorable factor. But I do want to put on people's radar screens that there is new guidance out there that is relevant to stays of removal and how ICE will consider them. Okay. Now, if someone is facing imminent removal, again, make sure that if there is something to be filed, that it is done as soon as possible. You can ask ICE to request prima facie determinations. This new guidance does not prohibit them from doing so. It just states that they will no longer routinely be asking for them. So I think there's no harm in asking for them to do it. And then again, the importance of filing a stay, perhaps if it's an essential order, doing a motion to reopen with the immigration court. And then please do kind of keep us looped in, and we can kind of use our liaison contacts to see make sure that the process is being followed as well as it can be. Again, by using your liaison contacts through us, to the ombudsman, through your member of Congress, to make sure that the survivor has an opportunity to have their case adjudicated before removal. And again, this landscape and these issues, literally change by the hour. Case in point, today we had these slides all prepared, and then, not even, 2 hours into our day, we have new guidance out there about, different changes, about the flexibility that they'll have in processing. So please do keep connected with us, and they have here on this website is a link to where all of these different agencies, for USCIS is keeping their updates, for ICE is keeping their updates, and then where we are keeping our updates, so that folks are aware of changes as they occur and as they happen, because this is really something that is a moving train, and all of this can change very, very quickly. So with that, we do have some time left. If you have any questions related to serving clients in this moment, or other issues that you're facing that are maybe non-COVID related, we're happy to stay on a few minutes and answer any additional questions that you might have. This slide is how to reach us, how to reach out for technical assistance, and where we keep all of our practice advisories. So we are happy to spend some time now, and we will wait for some questions to come in.
While we're waiting for questions to come in, I'll also put in a plug for our upcoming group TA calls. So in the last few weeks, we've started putting advertising calls where up to 20 people can sign up and just get on a Zoom chat with us to do some group TA brainstorming. And so we're going to keep that going. And the announcement is going to go out shortly with the remaining dates from now until the end of June, along with the registration links for each one. I
think we lost you, Amy.
Yes.
Okay, well, we will be sending that information out today with the remaining dates of those TA calls, so feel free to join us any one of those dates. The notice that's going out today will have links to registration. Because these are specifically for our OBW grantee members, there is a registration that will just ask you, whether you're an OBW grantee and what organization you are with, et cetera, in order to be able to join that call. But it's open to any issues, not just COVID-related issues. So if you have a particularly tricky TA that you want to just talk through rather than trying to type out all the issues in a TA, feel free to send us that by registering for the call, and then we'll talk through it then. The other great thing about our TA calls is that participants generally share other helpful tips and information, because as Cecelia said, things are changing so rapidly that everyone's practice is also changing rapidly, and the tips that are, working and not working are being shared during those calls, and I think that's been super helpful to everyone on the call. So feel free to join one of those. We do try to limit the max number of people participating just so that everyone gets a chance to fully participate and ask their questions. So if you can't get on one, please try to register for one of the other ones. And that's all we have. I don't see any questions. I don't know if Amy was able to get back on. I don't think she had anything further. But I think that's it for today. Thank you all so much for joining us. And we will follow up with you. The one item that I know I need to follow up with you is I will send out the Nebraska Service Center and Vermont Service Center hotline email addresses as promised earlier. And if there's any other information that you needed from today, feel free to get in touch with us at the emails on this PowerPoint.
Thank you, everyone.
Everybody,
have a great day.
Everybody stay safe.
Yes. Bye.